Just some kind of quick introductory remarks. I can't believe it, but we had 151 people here on Zoom today. That is amazing. Thank you so much, everybody, for being here today. Looks like we have about 30-ish questions as of right now, so I'm going to pop right into the questions. Okay, the first one is from a board member. When you have an owner who has lived in your HOA for decades with a history of delinquencies and past due write-offs due to a bankruptcy, if said owner is now delinquent again and the board is worried about another bankruptcy filing, would a new bankruptcy filing wipe out all of her past dues again? So great question. So you have an owner who's not paying assessments. Previously, they've effectively used a bankruptcy to get out of paying it. What I would want to do is I would want to look at how long ago was the bankruptcy, because there's bankruptcy laws that say that you can't refile a bankruptcy within a certain number of years. I think it's like 7 years, if I remember correctly, 6 or 7 years. So if you're not in that window, they're not going to be able to refile if they, got their debt discharged in the bankruptcy, recently. Another thing is, if you have an owner who has done this type of thing before, you probably need to be a little more aggressive and foreclose on this owner if they have equity in their property, because they may be just trying to rack up a bunch of debt and then refile it once the first time they can refile it once that year hits. So if you put the pressure on them before then to pay and they recognize that you're going to take legal action if they don't pay, I think that would be very smart. Okay. So the question, just to finish it out, was, would a new bankruptcy filing wipe out all the past dues again? I mean, it just depends. We have a really great cheat sheet on this topic called Trustee Sales and Bankruptcies, and I would encourage you to take a look at it. You can find that on our website at mulcahylawfirm.com. But the bottom line is, it just depends on what kind of bankruptcy they file and if they're in the right time to file it, like if they are eligible to file bankruptcy again after the first bankruptcy. A 13 is a restructuring repayment plan. A 7 is a total discharge. So it would just, a number of factors would depend, whether or not they would be able to wipe out their debt again. Okay, next question. If a governing documents don't require a board member to sign a code of conduct, do they have to? So we have a great cheat sheet on code of conducts too. You can find that on our website at mulcahylawfirm.com. Code of conducts are a really great tool to make sure that board members are aware of their fiduciary responsibilities to the corporation and to ensure that they're going to comply with your association's documents and keeping things confidential and acting in the best interest of the association. So I'm always in favor, if a board wants to have a code of conduct, I'm always in favor of the board considering having it. So here's the bottom line on the code of conduct. And again, look at our cheat sheet, because we have a sample on the cheat sheet that you can look at the language. If your board wants a code of conduct, you're going to have a majority of the board approve it. And if a majority of the board approves it, that means that everybody's subject to it. So even if your documents don't require you to sign a code of conduct, and I can't think of any that do, the way to get it implemented is to have the board vote on it, and then everybody, is going to then be subject to it. The board would just say that the entire board would be subject to the code of conduct. That would be the vote. There are times where I've seen board members that just say, I refuse to sign this. And I always think to myself, that's so odd, because you're saying, I refuse to, comply with the association's documents. I refuse to, comply with my fiduciary responsibility to the community. And I mean, it's just, all this stuff should just be happening. You shouldn't have to have a code of conduct to say it. It's a good reminder, but you should be doing this already. So when I have a board member that's saying, I'm not going to sign it, to me, that's a red flag, a big red flag, that this person is not understanding what their responsibilities are on the board. And maybe this would be a good opportunity for me to come in and have a boot camp with the entire board and talk about what your responsibilities are serving on the board, and talk out any difficulties that your board may be having, personality conflicts or disagreements on things, so that we can move forward. Because there's obviously a high level of dysfunction in your association if you have a board member who's refusing to, do the things that they're elected to do and are required to do under the law. Okay, next question. I need information on creating a conservancy for our 550 home HOA community in Tucson. We're facing challenges with a small group of residents who are repeatedly filing Arizona Department of Real Estate petitions against the board, claiming noncompliance with CC&Rs and state laws, and threatening lawsuits against the board and individual members. This has led to increased legal costs, rising from $5,000 to over $15,000, with next year's budget set at $25,000. Wow. Okay, that's a lot for a 550 home association. And we're now having a 10% increase in our assessments. Can you provide an estimate of the cost to create a conservancy? I think maybe what you're meaning is like a conservatorship. The average monthly and yearly costs of running one for our community, our size, and any other relevant information to present to the board and community about why a conservatorship may not be the best solution. Okay, again, another association where I think you've got like a high level of dysfunction right now in your association. And, the only way you're going to have a conservatorship for your association would be if an owner or the board files a lawsuit against the corporation and asks for one. So, I don't think, based upon what you're telling me here, I don't think that that's the path you should go. Usually, you have a conservator come in and manage the affairs of the association when the board is unable to do it. So you don't have a board, or the board is so dysfunctional that they can't get anything done. And it's like a problem, like they can't even agree to pay a bill, or, all the services in the community are being shut off because there's so many problems in the association. Those are the type of situations that I've seen a conservatorship, implemented with a conservator to run your association. And typically those do cost somewhere between $50,000, $75,000, $100,000 a year. And that's in addition to all your other expenses. So it's typically the court will just appoint somebody, they'll set the pay rate, and then they'll levy a special assessment that needs to be collected by all the homeowners. So I don't really think that's what you should be doing here. I think what you really need to do is you need a boot camp. I'm sorry I said that on the last one too, but I've been doing this for so many years that I know that you've got dysfunction right now. If you've got a lot of Arizona Department of Real Estate petitions pending against the board, and your board is struggling and has this much money in legal fees, something's not right here. This is not working. And so, but I know my office just shared in the chat some information on the boot camp, but I come in, I analyze the situation, I talk with the board, I listen to the homeowners, and we try to find common ground to move forward, because that's going to be a lot less expensive. That's going to be, like $2,500 in legal fees versus, your current $25,000, which is, kind of astronomical based upon, how small your association is. So I would really encourage you to get help. Things are dysfunctional, and having an independent person come in and talk with the board, talk with the homeowners, and find common ground, find where there are problems, and explain to the board what laws they may need to comply with that they may not know about, and listen and learn, and then create a plan to move forward so that things can be improved in your community. Okay, next question, number 4. Does ARS 1817 Section 2B apply to the planned community that is currently updating the CC&Rs? So you're looking at, okay, so my office is amazing. They put that actual statute right in the question for me here so I can read it. So this section talks about declaration amendment, and it says the amendment receives the affirmative vote or written consent of all the owners of the lots or property to which the amendment applies. Okay, that's a really good question. So you're saying our planned community is updating our CC&Rs, and do we have to get all owners' consent to update our CC&Rs? So we have a great cheat sheet on amending CC&Rs that you can find on our website at mulcahylawfirm.com, and it goes through what the 5-step plan is for amending CC&Rs. In this case, what I'm going to say is I think maybe you're taking a statute that has very limited applicability and you're trying to give it widespread applicability. So, what the statute says is, okay, if we're going to make a CC&R amendment saying that maybe in the past, all wrought iron fencing on the properties that had wrought iron fencing, like sometimes you'll have a community that has like its golf property where there's a golf course adjacent to the community, and sometimes some of the properties will have wrought iron. the example that would fit with this particular statute is, okay, the board, not all properties have wrought iron fencing, but some do. And so we pass a restriction in the CC&R saying the owners must now maintain the wrought iron fencing. The association will no longer maintain it. The owners that have wrought iron fencing should maintain it. Well, what this law says is, okay, if we're, singling out a certain category of owners, and this amendment only applies to them, we need to get their unanimous approval to change that in the CC&Rs. And that makes sense. But that is not widespread. That doesn't mean that you need 100% approval to amend your CC&Rs on any issue. That's just issues that only apply to certain owners. Kind of an interesting thing that goes along with this question is that there was a case decided several years ago now, the Callaway case, that talks about we can only do amendments in condominiums and planned communities if the amendments are foreseeable and reasonable. I mean, that's kind of a very vast interpretation of that law. So as you're thinking about amending your CC&Rs, make sure that you're reaching out to our law firm or your legal counsel to talk about, okay, is this something that we're going to be able to do this amendment under the Callaway case or under this 33-1807 2B? Strategize with your attorney or our firm, and we can give you advice on how to best navigate that case and also the statute so that you can have amendments that are sent to your owners for approval, and they will be legally approved. But we do kind of have to look at what you're planning to do and look at the law and see whether it's something that we'll be able to do without unanimous approval in your community. Okay, next question, number 5. Our management company sent our proposed 2025 budget to the former treasurer for review. The former treasurer and president reviewed the budget with board members one at a time and have not included the current treasurer at this point. Is this legal? So I think it's fine to have the former treasurer look at the budget. I mean, oftentimes, maybe the new treasurer needs help, or they're just willing to take a glance at it and give their opinion. I think that's totally fine. It sounds like less than a quorum of the board met with board members one at a time to talk about the budget. And that's also legal under the law. I don't know if you're saying they haven't included the current treasurer. That could kind of cut both ways. So are you saying that they're intentionally not including the current treasurer? I would think that is, it's not illegal. It's just unusual because the current treasurer really needs to be involved in this because they're the ones going to be held accountable for if we can't meet our expenses. And we need to have enough income to meet our expenses. So if they're, axing out the current treasurer, that's dysfunctional and that shouldn't be happening. Is this legal? I mean, I would say the things that they're doing, talking individually with the directors and having the former treasurer look at it, that's perfectly legal. But you really should be making sure that the current treasurer is involved as well. Okay, and then remember on the budget, you should be voting on the budget. And when a quorum of the board is present, voting on it to approve it. And if you're talking about the budget outside of a meeting, that's in an open meeting, you should be doing that. If you're talking about the budget outside of a meeting, it needs to be less than a quorum discussing it. Okay, next question, number 6. Has an owner, non-resident, who hounds our GM with, my HOA has an owner or a non-resident who hounds our GM with records requests and is driving up our legal fees. Is the legislature going to do something, or are we stuck with dealing with residents who make it so our GM can't do his job? I'm sorry to hear that this is happening in your association. Owners do have a right to transparency, and they do have a right to review the books and records of the association with few exceptions. So if you're in a situation where you have a resident who's basically harassing your general manager, you really need to escalate this to our firm or your attorney, because we deal with the situation, unfortunately, all the time. And so, if I were in this situation, I was the attorney, I would get in contact with the owner that's making all these records requests, and I would ask them what's going on. What is the problem? Why are you asking for all these records? There's always an underlying problem when somebody's making a lot of records requests. And so let's get to the bottom of the problem. And, if there's something in particular, once they explain the problem to me, I can usually say, well, if you're looking for the answer to that, I can get you the document. It's just one sheet and this is what it is. And, usually once I get involved, things get, the records requests stop because we get to the bottom of the issue and we get them the document that they want. Very occasionally, you'll have somebody who's very high maintenance and they just continue to make records requests. Just maybe there's mental illness involved. I don't know. I mean, I also have had that situation, and basically, we have to comply with the law, so we do need to respond to them, but we try to do it in a way that is not going to make it easy for that person, to continue to make the record request. So we charge them the 15 cents per page. We wait 10 business days to get them the records, all of which is legal to do. Okay, next question. We're hiring our first property manager. He says he is responsible by law for providing new residents with our bylaws, CC&Rs, and rules and regulations. Is that correct? So short answer on that is yes. I don't know how large your association is, but if you have 50 or over units or lots in your association, there is a law called the disclosure law, which anytime there's a new buyer, there's different categories of information that have to be provided to the buyer, and the association's documents are something that has to be provided. We have a great cheat sheet on this topic called disclosure fees versus transfer fees. I would highly recommend that you take a look at that. You can find that on our website at mulcahylawfirm.com. Okay, next question. Corporate Transparency Act. Can the report be submitted for the entire board, or must individual members file independently? So it can be, in my understanding is we're just starting to do it for many of our clients, and non-clients are also hiring us to do it for them, is that it can be submitted on one form. And that's we're just starting to do it too, and that's been our experience. Okay, next question. Does a small HOA of 12 homes have to comply with the CTA? So generally speaking, yes. We have on the front page of our website, on our homepage, we have a really great summary of does the Corporate Transparency Act apply to us or not. So go to mulcahylawfirm.com and check that out for a deep dive on whether or not it applies. It probably does apply, though. I'm just going to tell you, if you're a nonprofit corporation, it probably will apply to you. But go ahead and check out the frequently asked questions and the full summary on our webpage. Question number 10. One of our board members has told me that he refuses to provide his personal information to satisfy the CTA requirements. He is not a U.S. citizen. Do our condo documents, or does our condo community need to protect itself from possible fines? If so, what is required? Okay, so they are required to comply. All board members are required to comply with the CTA. If this particular board member doesn't want to comply, it is a problem. Either that person should consider stepping down, or maybe I need to have a phone call with them to alleviate any concerns that they may have under the Corporate Transparency Act. But there will be consequences for your association if this person does not provide that information. And honestly, it's going to be a big red flag to the government that this could potentially, be an issue, even though it's not. But the reason that they don't want to do it is, I'm assuming, because they don't want to give their passport information to the government. But the reality of it is now you're going to be flagged as potentially, one of these categories that this law was passed to protect. So you're going to have further scrutiny, which I'm sure that person does not want to have. So I would say all board members need to help on this. They need to provide their information. The government already has it. If you have a driver's license, they already have this information. So it's not like they're asking for anything that they don't already have. Okay, next question. What happens if we don't allow the information to be shared with the government as a board member? Okay, great question. There are penalties under the law. You can just Google penalties under failure to comply with the Corporate Transparency Act. There are very steep financial penalties for the corporation. And so we are encouraging everybody to comply. You can also look at our handout on mulcahylawfirm.com on the homepage of our website. We have all the information about the penalties, etc. Okay, next question, number 12. Is there any manner in which our property management company can overrule the direction of the board treasurer? I recommended putting some idle funds into simple CDs with the local bank, and the management company derailed my suggestion with their own recommendation after I'd already had it approved from 6 out of the 7 directors. Okay, well, this is kind of upsetting for me to hear that the management company is refusing to comply with the request of the board. Because 6 out of 7 directors, requested that the CD be used at this bank. I mean, oftentimes we'll see management companies that have a relationship with the bank, and they get a lot of special perks because all of the money of the associations is with this particular bank. You have to go back and look at your management contract. Did you agree to that? If not, you're in charge of your own money and you should be able to put it, wherever you want, as long as it's safe and, getting, competitive interest rates. That might be a situation where you're thinking like, hey, is this management relationship working for our community? Because they're trying to strong arm us to do what is beneficial potentially to them and not what we want to do and is beneficial to our association. Okay, question number 13. Does a co-owner ballot require numbers for board of directors election during annual meeting? Let me see what this means. Does a co-owner ballot require numbers for the board of directors election during an annual meeting? That doesn't make sense to me. So does it require numbers? I wonder if you're saying, do we have to say on the ballot what the number is that we need to elect the person, or does it require, I don't know. This is a perfect example of, I don't understand what your question is. So come back to First Fridays or another class that we're having, and maybe you can clarify for me or give me a call tomorrow at the office. And I'd be happy to answer that for no charge. Okay, next question, number 14. To save money on repairs, my community is considering leaving the entry gate open on weekdays from 10 to 5. Drivers piggyback in when the gates are closed, so I don't think this would be an increased safety risk, but it would leave the HOA open to legal action if a crime occurs when the gate is open. Do you agree? So yes, I would agree that if the board if the gates have been closed and now you suddenly decide to open the gates and then there's a flood of criminal activity, I do think there would be some liability for the board under the Martinez case that we talked about. I do see associations that leave the gates open, but usually it's not all day. Maybe it's just from like 7 to 9 or something in the morning, and then maybe from 4 to 6 in the afternoon. But I do think it does, create some liability for your association. Okay, question number 15. How do you handle board members who make judgments based on personal thinking, but not based on rules, the CC&Rs, and the bylaws? How do we handle them? Well, we let them know that, hey, you are elected and your fiduciary duty is to the corporation and you have to comply with the association's documents and state law. And if they continue to refuse to do that, I would document it in the minutes of the association. And I would have your attorney or my firm come in and talk to that board member. Okay, next question. Can a board member be on a committee as a homeowner and not as a board member, even though legally they are a board member? So I would say yes. Lots of times board members serve on a committee and it's, they're wearing a hat as a committee member or maybe as a homeowner going to the committee, and I think that's totally fine. Question number 17. When notifying owners of board and board committee meetings, do we need to provide the notice to all owners of the association? Does this notice need to be emailed to all owners? Okay, so the only time, so for all board meetings, so anytime a quorum of the board is meeting to discuss association business, we have to give 48 hours notice under the law to the owners. And that can be done and you got to include the agenda, like we talked about at the beginning of this class. So 48 hours in advance of the meeting, the board should send out the meeting notice and the agenda. It can be done a number of different ways. You can email it, you can put it on your website, you can put it on sandwich boards that are located on the association's common areas. There's lots of different ways to tell the owners about the meeting that would comply with the law. Now we go to board meetings. So do we have to provide notice to the owners of board meetings? The only time under the law that you have to provide notice of board meetings is if they are regularly scheduled committee meetings. So if there is a regularly scheduled committee meeting, you treat it just like a board meeting. You got to give 48 hours in advance. And I would say best practices would be to also include the agenda. So what does regularly scheduled mean? We have our architectural committee meeting the first Friday of every month at 8 a.m. That is a regularly scheduled meeting. If you have an architectural committee that only meets when you get applications in, that's not a regularly scheduled architectural committee meeting. Okay, it's just not something that you would have to have that notice because you don't regularly meet. Okay, let's talk about question 18. When doing the state-required elections for parking, can the announcement or meeting include comments by board members which show favoritism towards maintaining or not maintaining on-street parking limits? So many of you may be aware of a law that was passed in the 2023 legislature that talked about associations that are planned communities that have streets that are dedicated to the public, and the need to have a vote of your members to be able to retain enforcement of the public streets, the parking on the public streets. There's a law that was passed again in 2023 on this, and it says that we have to take a vote by June of 2025 to keep that enforcement ability available. So this question pertains to that. So you're saying when we're doing this state meeting that's required, can the board, make their comments one way or the other on this? And I think the board certainly has a right to provide feedback on this. As board members, they certainly have a right, but also homeowners, if they're in favor of it or opposed to it, they also should have a right to talk about this. Okay, next question, number 19. Does an HOA board have any legal responsibility for one of their committee members harassing a resident? Should they be removed from the committee for this behavior? So absolutely, there's liability if a committee member is in any way harassing a resident, and this should be addressed immediately with the committee member. Whether or not they're removed, it just depends on the facts and circumstances, but this is unacceptable behavior and it's easy to remove a committee member, so that would probably be the likely thing that would be done. Of course, I always like to listen to all sides of the story, so I'd want to hear from the committee member what exactly is going on. Okay, question number 20. Is the HOA's board or management company still required to provide notice of an annual meeting and provide board agenda, budget, election of new officers? For the first time since 1996, we have not been provided the information, only a banner at the neighborhood entrance saying annual meeting Wednesday and an email stating Zoom annual meeting tomorrow. Do we have any recourse? So, for annual meetings, we have a great cheat sheet on this too. So go to our website at mulcahylawfirm.com and you can take a look at our annual meetings cheat sheet. Here's what the board has to do to comply with the annual meeting requirements. So you need to check your bylaws. How far in advance of the meeting does the notice of the meeting need to be sent? That notice needs to be sent by U.S. mail or by hand delivery to your residents by law. The notice, if you're following state law, it needs to be sent out not less than 10, not more than 60 days in advance of meeting. Also, every owner should be allowed a chance to vote by absentee ballot or in person at the meeting. So that ballot the absentee ballot should have been included with the notice of meeting. And so do they have to include the agenda? I think best practices would be that they should include the agenda. It's sort of gray area as to whether the agenda has to be included in the annual meeting packet based upon the way that the new statute was worded. Most people are interpreting it that it just applies to board meetings. But we're saying, okay, yes, it does appear to only apply to board meetings, but best practices would be give the agenda for committee meetings that are regularly scheduled and also for the annual meeting. So do they have to provide the budget? No, they don't. Is it a good idea if that's something that's going to be discussed? Yes, or tell them in the notice where they can find it on the website of your association if they want to save money by not mailing it. Should they talk about the election of the new officers? Well, that would be on the ballot, so that would be covered there. So I do think it's unusual that your association, it's just seeing the notice and they don't have any of this other information. Maybe they sent it and you didn't receive it. It might be a good time to check in with your board and find out if they actually did send this out to the entire community. Okay, is it legal, number 21, is it legal for a master association to delegate enforcement responsibilities to sub-associations? So yes, it is, and that is pretty common practice with most master and sub-associations. I mean, some masters, do it for the entire community, including all subs, but most of the time they let the subs do the enforcement. Some master associations enforce their restrictions and let the subs enforce theirs, meaning their CC&Rs. It just really depends on how it's set up for your association. But what you're telling me is not anything that's unusual. Okay, question number 22. Our management company had us purchase a commercial liability policy. It covers business liability, employer non-owned auto liability, hired auto liability. The serving agent is the management company. I don't have this at my prior HOAs. Is this required? Well, it just depends on what the management company had in their management contract. They probably made that a requirement that insurance would be carried by the association. And so is it something that every association, the management company requires it of? No, but some do. And I bet if you look at your management contract, that's something that's required in the management contract. Okay, question 23. What obligations does a management company have in regards to complying with open meeting laws and obligating a community to long-term contracts or payment of expenses out of ordinary monthly obligations that they pay every month? Okay, so this is a compound question. So what obligations does a management company have to comply with the open meeting laws? They should be advising their clients, the associations, to always comply with the open meeting law. They should be helping their clients comply with it, making sure that all the notices are posted. That's their job. In terms of what about the management company obligating us to a long-term contract? They really should not be doing that. The board makes the decisions on long-term contracts. Like payment of expenses, that's just really going to be something that you have to work out with the management company. Some association boards delegate payment of expenses and they give the management company a lot of authority and they delegate a lot of the responsibilities for signing checks, approving expenses to the management company. Other associations, may micromanage it more. Maybe they set a limit. Anything over $5,000 needs to have approval by the board or signed by the, 2 board members or something like that. It really just depends. That's something you should talk about with your management company. Look at what the management agreement is that your association signed and move forward. Okay, question number 24. And I'm just going to do a quick check how many we have total. Looks like we have about 38 questions. So question number 24. Under crime prevention, incorporating audio recording into video surveillance may be legal under one-party consent law, and the Citizens United decision enables corporate entities to claim to be that one party. But when an owner or resident objects to their conversation being recorded, what's the best way to stop the board or administration from deploying microphones? Okay, this is kind of an unusual question, but I'm assuming, let's see, you're doing video surveillance and then there's apparently some sort of they can hear you, you can hear them type of thing, and then they tape it. I haven't had this question before. I have had the question like if, we're taping a meeting of the board, on Zoom or whatever, that we do announce that the meeting's being recorded, just like today. If you look in the screen, I'm sure you'll see somewhere that the meeting's being recorded. I guess what your question is what's the best way to stop the board from, deploying microphones? I don't have a problem with them, like recording board meetings. That's customary in our industry and state law allows for it. I would have to find out more about what they're doing on your common areas with surveillance and video. I do know, like my association where I live, we have this technology at our pool, and if somebody's misbehaving, the security guard can be like in their security office, and they can send a message over the announcement, like, "Hey, stop jumping off the ledge into the pool, off the ledge 10 feet high into the pool, or whatever." But I don't know if they're recording it. I bet the video is being recorded. I just don't know about the audio. So I can't comment too much upon that. I do, my office put the statute up here on the screen. I'd have to analyze it, probably an opinion letter, and that probably exceeds the scope of today's questions and answers. Okay, question number 25. Our CC&Rs have a rule that occupied residents must have at least one resident age 55 plus. Over 80% of the occupied residences comply with the rule. Recently, a resident died and left the home to her 45-year-old son who wants to occupy the home without having someone age 55 living there. He believes that since we comply with the 80% rule, we cannot enforce our rule and prevent him from occupying the home. Is that correct? I'd have to see what the provision in your document says about, 55 and over housing, and can somebody who's 45 live there or not. What I can say from my experience is I need to look at your documents, and then I can analyze as to whether, we can, from a legal perspective, we can prohibit that person from living there. I don't know if it's mandatory that 100% of your owners have to be 55 and have an occupant that's 55 or over in the unit or lot or not. So it's hard for me to comment on that. What I can say is that in most situations, when we have the spouse who's 55 passes away, we typically make an exception and let the family members stay there. Like for example, husband and wife, the husband's 55, the wife's 35. We don't kick the wife out typically or tell her she has to sell. That's kind of what we save the 20% for. So in case we have a situation like that, we, push them into that category. That's typically what we do. Okay, but again, you have to look at what your CC&Rs say and go from there. And you definitely want to reach out to your legal counsel if you're the association, if you are going to force that person to leave, because you want to make sure you're on solid ground. Okay, question number 26. Fair Housing Act and a request for a modification to the common area sidewalk in a 55 plus community for a ramp cutout to allow easier access to and from the laundry room for a resident. That's the issue. To confirm, is this something that the HOA does not have to pay for and can require the owner or resident to pay for it if wanted? So if you're not a place of public accommodation and the Americans with Disabilities Act does not apply to you, then yes, this is something that the association can require the owner or whoever, the resident, to pay for if the resident or owner is asking for it. However, in most situations, the board gratuitously does it, even though they're not required to pay for it. Something small like this, they usually are a ramp that's, like a movable temporary ramp. Usually the board just pays for it and just does it. But if you want to be hardline on it, yes, you can make the owner who's requesting it pay for that. Okay, next question, number 27. In a 55 plus community, are we required to allow an owner's handicapped child who is under the age of 40? Our governing documents set 40 as the minimum age for the second occupant. So really great question. There's a case on this from Northern Arizona from many years ago. I can't remember the exact name of it. I'd have to look it up, but it's this exact fact pattern where parents have a handicapped child living with them. It's a 55 and over community. They ask for a reasonable accommodation under the law because their child has a disability, and the association was required to grant that reasonable accommodation. So if you're in that situation, you would not be able to enforce the documents against that particular resident and make their child move out. Like I said earlier in the presentation, you can ask for certain categories of information from the resident, like doctor's note, etc., and that you can try to find the connection between the disability and the requirement that they live in the property. But I'm guessing that that's going to be pretty easy for them to do. So just gives you some baseline knowledge that you can't, that you probably are going to have to grant a reasonable accommodation on that. Okay, question 28. We have 2 large projects for our community that will increase the capitalization fee. We had a work study meeting and only 14 residents attended. We will be presenting it at a board meeting this week. One board member said we need to do more work study meetings for better attendance, but we have a deadline with the city on the projects. Do we need to delay and do more work study meetings? Only you know the answer to this question because it just depends on how controversial it is, right? I mean, I've had associations that this would be smooth as can be. if there's not a lot of contention on this issue and it's needed and it's not going to, break the bank, typically it's going to be, and you have the money for it, it's not a big deal. But in this case, you're having something that's going to increase the capitalization fee. Now, I don't know what you mean by that. I don't know if you mean that you have a capital contribution fee and now we're going to be charging more to buyers for this, or you, maybe you're going to do a special assessment. I don't know. But my baseline advice on this is if it's controversial, if it's going to cost more money, and you've only presented it to the board at a work study meeting and maybe one board meeting, maybe you need to pump out more information on it electronically. Maybe you need to have a town hall on it if you think this is going to be really controversial. I don't know. So you best know whether this is going to be an issue. You could move forward with it, and then if people get upset about it, then you can kind of backtrack a little bit and have that meeting. That's another option too, although that there might be a lot of unrest in your community, to get there. But short answer is, the facts of your community, and if it's going to be a problem, then I would wait and get more community education on this. If it's not going to be, then I would move forward. Okay, question number 29. We have an owner who blocks or harasses contractors who are hired to provide services. He has been asked on multiple occasions to leave the contractors alone, but continues to ignore that request. What are our legal options? This question kind of scares me a little bit because these are kind of like the very same facts that were in that West Valley Association. Long time ago now, 20 years ago, where we had a resident who was doing something like this, wasn't allowing the landscaper to come on his property, and ultimately, left the community because he lost his home in a trustee sale, and then came back and, shot several board members and killed several board members. So this to me seems like a situation that you want to get your attorney involved in or have our firm help you with, because this person is obviously intentionally doing it. It's happened multiple times, and there needs to be a cease and desist letter sent to this owner, and there needs to be an evaluation like, hey, is this person really dangerous? And if they are, what are our legal remedies to deal with this person? And I'd be happy to help you with this if you reach out to our firm. Okay, next question, number 30. My understanding was that the note indicating the existence of a disability only had to come from a caregiver, which can be broadly defined. That caregiver doesn't even need a physician or professional credentials. Is that correct? No, that is not correct. You do need to have a note from a physician to support a claim of a disability. Okay, question 31. Didn't a new law go into effect, I think, July, that requires all group homes, even those with 5 or less occupants, to register with the county or the state? So yes, we're going to be sharing with you in the Zoom chat and then also on Facebook Live a link to a bill that was passed into law in 2023. And this law specifies that group homes and behavioral support group homes are exempt from complying with zoning standards for healthcare institutions, and that behavioral supported group homes and group homes operated in Arizona by a service provider and under the contract with the Department of Economic Security to be licensed through DHS. It also talks about types of rules that DHS director must adopt regarding behavioral supported group homes, and modifies the definition of group home to specify that behavioral supported group homes is not a group home. So there are certain group homes that are going to need to be licensed to the DHS as per this law. The other one, sometimes we see a group home, that isn't, that doesn't fall under one of these categories. And I believe that the cities and municipalities still are regulating those. They have a permit that they have to get. And so you may want to reach out to your city, town, or municipality to get clarification as to what requirements they have. But I can tell you from experience that anytime there's a problem with the group home, we reach out to the city, town, municipality, or county, and they are typically, registered with the city, town, municipality, or county. You can also check on licensing apparently through the Arizona Department of Health. So that may be another option for you to go to. Okay, question number 32. Is it a conflict of interest if a board spouse is on the finance committee? I don't really see a conflict. I mean, we have lots of times where we have spouses of board members who volunteer on things. I don't see it as a conflict of interest. An investment was made in a non-FDIC account. Should that have been made without our residents' vote? Okay, so we should not be investing in any high-risk investments. So everything needs to be FDIC insured, in my opinion. So that, is, you don't need a resident's vote for that, but the treasurer of the association should not be allowing that. Okay, next question, number 33. A concerned homeowner raised operational questions to the head of security, who replied saying those were operational questions and should be raised to the homeowner's board member. Homeowners tend to think operational questions should go to the community manager or the appropriate department head if they run operations. If a homeowner asks a board member, it seems the board member would need to go to the appropriate employee to get answers anyways. It seems this HOA is saying homeowners are not allowed to ask operational questions directly to administration. How should homeowners handle a request like this going forward? Just follow what the board's asking you to do. Go to a board meeting, ask them to look into it. For whatever reason, the management company doesn't want to answer to you directly. I mean, that's kind of a little bit of a red flag to me, but I don't know what kind of questions you're asking. Are you asking like how much the manager is getting paid? Or I honestly don't know. That probably would be something that I would say they probably wouldn't want to give you, and they direct you back to the board. So I think that the appropriate party for you to contact first is the board. If it was something easy, I would say management company, just tell them it, just to get things moving on here. Okay, question 34. Are there legal actions homeowners can take if the board of directors fails to comply with and enforce the community's CC&Rs? Additionally, what recourse is available if the board is not adhering to the terms of the management company contract with the community? What steps can be taken in these situations? So, okay, what can homeowners do if the board isn't complying with the CC&Rs? I mean, there's lots of things you can do. You can, come to a board meeting, express your concerns. You can write a letter to the board or an email to the board, express your concerns. You can hire a lawyer, have the lawyer write a letter. You can go to the Arizona Department of Real Estate and file a complaint. There's a fee for it. You can Google Arizona Department of Real Estate and HOAs, and the whole thing will pop up. It applies to HOAs and condos, and it's a whole information sheet, great information there. You can file a lawsuit. You can move. You can run for the board yourself and try to make change from the inside. These are all things that you can do if the board isn't enforcing their CC&Rs, or maybe they're not living up to the management contract. I don't know which section the management contract they're not living up to, but those would be some examples of things that you could do. Okay, question 35. Our board meetings and committee meetings are held upstairs where there isn't an elevator or any ADA accessibility. Is there a requirement by law that we have to offer that? So again, you're probably not, the ADA is probably not, you're probably not an ADA community unless you're a place of public accommodation. So you wouldn't be required to meet the requirements of the Americans with Disabilities Act, which may have, that specific requirement in there. But I don't think that's going to apply to your association. I haven't seen your association's documents. I can't say for sure, but I doubt you're a place of public accommodation where the general public can just come in. So the question is, do we have to have it in a place that is accessible to residents that are disabled? So I would say make every effort to do that. Try to find a location where everybody feels welcome to attend the meeting. If you're not able to do that because of the configuration of your association, then have it on Zoom so that person can appear on Zoom. Try to be inclusive of everybody in your community, okay? Maybe you could have a ramp that's installed so that person can come to the meeting. But what we don't want to have happen is say, hey, I'm being discriminated against because I, can't come to your meetings because of the location that you're having it in. And I will tell you that probably wouldn't be looked upon favorably by the Attorney General's office if this got escalated. So be a good board, include everybody, try to have it in a neutral location, or maybe move the whole thing to Zoom so everybody's on Zoom. Okay, next question, 36. We only have 3 more questions. I have been an HOA president for more than 20 years. Attorneys have always told me we should not mount cameras, should not display signage about surveillance. They tell me it could create liability by creating a false sense of security that may not exist. And if we do not have enough cameras, if they are not always functional and they do not record for any reason, then we may be liable. What do you think? We have a great blog on security cameras that I would encourage you to take a look at. I think we're sharing it on Zoom and Facebook Live, or you can find it on our website at mulcahylawfirm.com. I mean, I guess I don't share your prior counsel's view on this. I think that cameras can be a beneficial things to associations. They provide, I mean, just in my association, we have cameras, and when there's, theft and damage, there have been times where we can pinpoint it to an owner or resident, or we give the surveillance to the police. Not always are we able to determine who it is, but 90% of the time we usually can figure out who it is, and that's helpful. Does it create a false sense of security? I don't think so, because our signs clearly state that there is not somebody there monitoring it 24 hours a day. I do not like fake cameras, that are, that people see the camera and they think it's a camera, but it's actually just a dummy camera. I would not do that. I mean, obviously everybody has different opinions on cameras, and I'm sure there are pros and cons on everything, but I think the pros, in my opinion, outweigh the cons. Okay, number 37, do condos built in Phoenix between 1962 and 1965 have individual main water shutoff valves for each owner? I do not know the answer to that, but what I would do if I were you is I would reach out to the city of Phoenix and ask them. They may have that information for you. Okay, last question for today. Can the board attend an HOA community potluck and answer questions from homeowners that come up while eating and having fun? So if a majority of the board is attending the potluck and a majority of the board is discussing association business, it really needs to be noticed as an open board meeting. If an HOA board member is at a potluck and it's less than a quorum, you don't have to notice it as a meeting. If you have a quorum of the board at a potluck and they're not together talking about association business, like at the front of the room, while people are dishing up their hot dish, they're in the front of the room doling out advice or whatever, talking about association business. If they're not doing that, if there's like a board member at one table and the quorum is all spread out, they're not talking, I don't think you need to make that a board meeting. Okay, here's some conclusions from today. We had just a really great turnout, so thank you everybody for being here today. We are really looking forward to joining us on our firm's 28th birthday. We're going to have a little birthday party on Friday, November 1st, where we are going to be having our firm's first Friday free call-in, which is virtual. And that's actually 28 years to the day I started my firm, which is kind of crazy. I'm actually going to tell the story of the day that I started my firm. It's pretty funny, actually. We'll save that for when we log on First Fridays. That's going to be our firm's live virtual First Friday event on Friday, November 1st at 9 a.m. If you're not familiar with live virtual First Fridays, this is a monthly event, live question and answer session, where we hop on and we answer your question for free. Every association can answer or can ask one question and we will answer it. And we just go through it rapid fire, just like we did the questions here today. Also, we want to remind you that class number 11, our November class of the 2024 Virtual HOA Condo Academy, is going to be held on Tuesday, November 19th at 11 a.m. And the topic for that class is going to be solutions for rental properties and parking headaches. So we're going to talk about how to best handle rental properties, including a discussion on short-term rentals and how to best manage those, and parking issues. And as always, we're going to have a free question and answer session at the end of the class. Note, our November class will be our last Tuesday session of 2024. So we always have our neighborhood services classes the third Tuesday of every month at 11 a.m. In December, we take a hiatus, and instead we combine our December class because of the holidays with our First Friday. So our December First Friday event will also be our December neighborhood services event. And typically we log on and answer all of your questions. And we kind of give a little overview of what's going to be happening in 2025 as well. So thank you so much for being here with us today. Appreciate you being here. We had a great turnout today. Look forward to seeing you on November 1st. And if you have any questions, you're always welcome to reach out to our firm. Take care, everybody, and have a great rest of the week.